Hi, so good day. On this lesson, we will be discussing how one can protect his or her ideas through intellectual property rights. So you may be surprised at how many aspects of your business can be protected. Your name, also your logo, designs, inventions, works of creativity or intellectual effort or trademarks that distinguish your business. These are all could be your intellectual property para di masundog. So,
By definition, ang intellectual property rights daw, these are legal rights that provide creators protection for original works, no? Take note, original works, inventions, or the appearance of products, artistic works, scientific developments, and so on. So, para dili masundog. So, for our objectives, mo ni nga to ang learning outcome today. So, we must be familiar with the intellectual property rights and then know the importance of IP or intellectual property. And then understand the several intellectual property rights. So we will be discussing them one by one, how to register. So learn about the registration process. Ayan. So the purpose of intellectual property rights, first is to, encourage new creations, including technology, artwork, and inventions. This might increase economic growth. Yan. Kaya, intellectual property is important. So, ang intellectual property, it also increases incentives for individuals to continue to produce things that further create job opportunities, new technologies, while enabling our world to improve and evolve even faster. Moreover, your IP rights are important because first they set your business apart from your competitor. So this serve as our competitive advantage. So when we say competitive advantage, anong meron ka na wala sila? Moreover, si intellectual property, they can be sold or licensed, providing an important revenue stream. And it offers customers some new and different form, something new and different. So, form an essential part of your marketing or branding. So, makabantay mo katong time nga nauso ang sakit sa manok. So, ang mga tao, wala ni palit og mga manok sa market. Ang ilahang paliton is ang mga manok gikan sa mga known brands because they trust the producer like Magnolia, or ang uban ni hinay ang chicken. Pero si Jollibee mo og gihapon, kusog gihapon. So instead of buying chicken sa market, mukhaon na lang sila sa Jollibee because they trust the brand ni Jollibee, the process ni Jollibee. So they trust Jollibee. Bisan pa katong kahinumdum mo sa towel, na possible nga kahinumdum mo sa towel nga gi-fried. Katong time nga naigi-deliver nga fried chicken from Jollibee. And then, naay towel. Naapa mo diha? Ayun. So, familiar mo ato nga story. Katong delivery. And then, naay towel. Pag open nila sa Jollibee, naay towel. Okay. So, daghay ni tuo, pero daghay still loyal pa rin kay Jollibee because of the brand. So, it can also be used as security for loans. Kay mo trust ang ato ang mga stakeholders. So, importante kaayo ang patent because ang intellectual property. So, patent is one of the intellectual property rights. So, if naa kay ingon ani asset na nimo because pwede gali na nimong ibaligya just like how Mang Inasal sold their name kang Jollibee Foods Corporation, di ba? And to exploit your intellectual property fully, this makes strong business sense to you. So you have to secure it. So you can then protect it against infringement by others and ultimately defend it in courts. Your sole right to use it or make or sell or import kana nga imong giprotektaran. And then stop others using, making, selling, or importing it without your permission. And then you can also earn royalties by licensing it. and exploit it through strategic alliances. So, royalties, maghatag og royalty nimo, just like halimbawa, ganahan ka mamaligya og siomai. So, you can use Siomai House. Dapat meron kang franchise ni Siomai House before you use the name. So, exploit it through strategic alliances. And moreover, lastly, make money by selling it. Yan. So, according sa World Intellectual Property Organization or WIPO, ilang gi-categorize ang intellectual property. So, naay duha. Ang first is intellectual industry property, and the second is copyright. So, under ni industry property are inventions or patents, no? Ipapapatent mo ang usa ka invention. Trademarks, industrial designs, geographic indications of source or GI. Kining GI, mao ni siya ang product which are used to identify specific place. Halimbawa, ipapa-GI natin ang vacuum fried ni jackfruit. We can use bye-bye jackfruit, vacuum fried jackfruit. So, GI products possess a quality, characteristic, or reputation essentially attributable to its geographic origin. Si copyright, these are novels, poems and plays, films, musical works, artistic works such as drawings, paintings, photographs, sculptures, and architectural designs. So, yan ang ating mga types or categories of intellectual property. Mao ni ato ang intellectual property. So, usa-usahon sa nato si copyright, related rights, trademarks and service marks, geographic indications, industrial designs, patents. So, patents under lang siya ng IP, layout designs or topographies of integrated circuit, protection of undisclosed information or mga information na hindi natin sasabihin. But alam siya ni example, ingredients of a product, no? So, kinahanglan makita siya sa gawas pero naatay secret nga timpla like unsa kadaghan ang salt, unsa kadaghan ang milk. So, pwede na nimo undisclosed. So, in the Philippines, the agency of the government which is responsible for the implementation of Intellectual Property Code is the Intellectual Property Office of the Philippines or the IPOPHIL. So they replaced the Bureau of Patents, Trademarks, and Technology Transfer. So kanang duha iyan ang gi-replace. So they are handling the registration and conflict resolution of intellectual property rights. So this is divided into 6 bureaus. So the intellectual property system dated back sa una pa sa Spanish and American colonial periods. And then we, or the IPO, this earned the reputation nga ang Philippines daw is among the first Asian countries to adopt laws on intellectual property. Ang 6 bureaus sa ato ang IPOPHIL is kani, Bureau of Patents, Bureau of Trademarks, Bureau of Legal Affairs, Documentation, Information, and Technology Transfer Bureau, Management Information System, and EDP Bureau, and the Administrative, Financial, and Personal Service Bureau. So, kini nga mga bureau, mo ni ang specific nga mga nag-implement sa ato ang code, under na siya sa IPOPHIL tanan. So, we have a Republic Act or a law on Intellectual Property Code of the Philippines. This is the Republic Act number 8293, which this is an act which is prescribing the Intellectual Property Code and establishing the Intellectual Property Offices sa Philippines. So they provide for their powers and functions and for other purposes. So this act, it took effect on January 1, 1998 under the presidency of Fidel V. Ramos. So there are several, or we will be discussing several intellectual property rights. The first is patent. Ayan. Kilala ang patent. So patent is a grant or a privilege issued sa government through the Intellectual Property Office of the Philippines or IPOPHIL. So it is an inclusive right granted for a product. process or an improvement of a product or process which is new, no, dapat new, inventive, and useful. So this is this exclusive right gives the inventor the right to exclude others from making, using, or selling the product of his inventions during the life of the patent. So na ay life ang patent. Maano siya gihapon, ma'am? Meron lang coverage, which is 20 years of protection. So the patent owner must share in kapalit. The patent owner must share the full description of the invention. So dapat mahibaw. Example, ipapapatent nato ang dapat i-disclose kumbaga ang information. So patent law protects the inventions or the utility patents and ornamental designs for articles of manufacture like design patents. So inventions protected by utility patents include any new and useful process. Pwedeng machine or manufacture or composition of a matter. Ang inventions, this can be electrical, mechanical, or like chemical in nature, yung composition. Examples of inventions nga protected by utility patents are microwave ovens, genetically engineered bacteria, no, for cleaning up oil spills. Pwede rin computerized methods of running cash management accounts. And also, pwede rin ang methods of curing a rubber. So, that's for the patent. So, what are the unsay tawag ani? What are the patentable inventions? So naagi hapon di ay tay requirement. Ang patentable inventions are any technical solution of a problem in any field of human activity which is new, which involves an inventive step and is industrially applicable, shall be patentable. However, there are non-patentable inventions. What are those? These are discovery, scientific theory, ayan, di siya pwede nimong i-patent. Yung discovery, halimbawa, naka-discover ka ng mga bagong metal, na siya sa atong nature. Na siya sa atong nature, so dili siya pwede ipapatent. And, baga existing na siya daan. So, another is scientific theory, no? If na scientific theory, dili pud ta pwede magpapatent ana. So, another pod is mathematical methods, scheme, rule, and methods of performing mental acts. So, dili siya pwede ipapatent. And then, playing games, dili siya pwede ipapatent. Doing business, program for computer, methods for treatment, human or animal body by surgery or therapy, and diagnostic method, plant variety or animal breeding, or essentially biological processes for the production of plants and animals. So, dili siya pwedeng ipapatent. And also, aesthetic creation. So, dili siya mabelong sa patent. Ang aesthetic creation, mabelong siya sa katong industrial designs. Contrary to the public order or morality. So, halimbawa, magpapatent ako ng ingredients ng or combination ng marijuana and chocolate. Hindi siya pwede. And what are the requirements for patentability? Again, novelty or the newness of the invention. So, dili pwede ka ng, halimbawa, ako ipapatent ang design sa, or ako ipapatent ang paghimo og face shield. So, dili siya pwede, kay naa na siya daan diha. At the same time, if si face shield na ay different nga uses ka na, pwede pa, like na inventive step. Kining sa novelty class, dili pwede nga naanay prior sa imuhang pag-fill up sa application form, dapat wala na-publish ana, nga ingon ana, wala siya na i-known sa public before or na print out before ka mag-file. And then, para ma-appeal ka sa or para makapasa ka sa novelty nga requirement. And then sa invention pod, dapat na inventive step. So, morning i-patent eh. So, if having regard to a prior art, it is not obvious to a person skilled in the art at the time of the filing date or the priority date of the application claiming the invention. So ang inventive step, this meant that the invention must differ significantly, no, from what is already known. So the solution must not be obvious to a person skilled in the technical areas. So dapat dili obvious ang solution nimo. Dapat nay something new sa imong step. So that means new ways of combining methods or objects are not necessarily patentable. So whenever anything inventive is done for the first time, it is the result of the addition of new idea to the existing stock of knowledge. So sometimes it is the idea of using established techniques to do something which no one had previously thought of doing. So in that case, the invention idea or the inventive idea will be doing something new, no? Something, it is finding a way of doing something nga people had wanted to do but could not think of how to do it. So the inventive idea should be the new way of achieving your goal. So in either of these cases, many people may have a general idea of how they might achieve, no, a goal, but not know how to solve a particular problem which stands in their way. So if someone devises a new way of solving the problem, the inventive step will be the solution, but not the goal itself or the general method of achieving it. So ang dapat na inventive step. Next is the industrial applicability. So si industrial applicability, in order to be patentable ang isang bagay, ang invention dapat industrially applicable, or it is considered to be producing or utilized, it must be utilized in any kind of industry, no? So in broader sense, ang industry also are the activities like in mutap sa like transportation, agriculture, or hunting, public services, and medical services. So the requirement of industrial applicability also means that an invention which is clearly infeasible with regards to well-established law of nature, for example, perpetual motion machine, so it's not patentable. Like pwedeng machines, no? Regardless of these three conditions, so tanawon gihapon na nila, ila gihapon i-assess if despite nga nakapasa ka ana, naabay babag or naabay like naay. So ang requirement in filing a patent, so ayan, magsa-start siya sa request of the grant of a patent, and then the description of the invention sa claim, drawings necessary for the invention if any, and then filing fee, of course, so naibayad. So that is for the patents. So much for that. Dito naman tayo sa trademarks. So, ang trademarks class, this means any visible sign capable of distinguishing the goods or the trademark or services or service mark of an enterprise, and shall include a stamped or marked container of goods. So, usually si trademark makit-an siya sa sudlanan or container. Trademark is a tool used to differentiate goods and services from each other. So, ang trademark, yan. Before applying a trademark sa registration, it would help you if you conduct a research muna. Mauna siya ang website. Mag-guessing game sa ta. I will provide you the trademark and then you guess kung ano ba to. Ang sa nga company or what are the services they are offering, no? Sige. I will show you protected group of words or signs. Kini unsa ni? Okay, Adidas. Very good. Kini? Yes. Pepsi. Ayan. Through that mark, you're able to connote, no, their products. Kini? Yes. So, si Chanel, no? Or naa siya gi-offer nga mga bags, suit, purses. Kini class? Okay, Toyota. Naku, nadungog Mitsubishi. Toyota siya. Okay, ito. Naikailaan ni. Oxy? OD. Yes, OD. So, yan ang kotse ng OD. Javili. So, last na may makitaan nga ingon ani, makabantay mo sa mga logos na ay mga, yes, na ay circle R symbol. So, that mark means ang usa ka logo or symbol is registered federally sa US Patent and Trademark Office. So, or either, pwede pod sa principal registrar or supplemental register. So, ang TM naman pod, dili ka need og registration para mag-put og TM sa imuhang mga logo. So, ibutang lang ni siya sa particular word or symbol or logo. This will serve as an identifier for the source of that product or service on sabay company. So, you do not have to be registered para magbutang og TM. Si circular R lang ang dapat registered. Ayan. So, we have Coke. Kini nga group of words. Are you familiar with this? Okay. Jollibee. Kini class. Familiar mo? Abot mo ang mundo sa globe. Kabantay mo sa logo sa globe na ikamot. Yes. Kini class. Abti kanila ay BDO. So, we find ways. Ayan. You are able to identify their services. So, unsaon pag-register sa ato ang trademark? First, you file and pay for your application online. Pwede pod mo moadto personally sa ilahang intellectual property office. So, naata ni sa Cebu. And actually, class, pwede mo register og IPO through the Department of Trade and Industry Office sa ilang mga negosyo centers. So, na sila yung mga file, kanang application form dito. So, mutabang sila ana. So, if you receive a registrability report from IPO, you must file a response to it within 2 months from the mailing date. So, naapay registrability report, no? Tanawon nila, i-assess anay nila before ka itugtan. So, your application will be published for 30 days in IPO website. So, if there is no opposition, IPO will release one certificate of registration once ma-approve na ang imuhang trademark. So, to proceed class, so ganina, nag-discuss tag patent, and then karon trademark. So, nga rin na punta sa copyright. Copyright infringement. So, si copyright infringement means violation. It consists in infringing any right secured or protected under the code. So, it may also consist in aiding or abetting. So, such infringement. Halimbawa, abetting means you stimulate, you cause in the infringement. So, possible din nga liable ka ana. And also, the law provides liability sa tao nga at that time makitaan or na naggunit or nagpossess when copyright subsists in a work has in his possession an article which he knows or ought to know to be an infringing copy of the work for the purpose of the following. So, excuse me. Unsa may mga possible nga mga purpose nimo? Possible nga ganahan ka i-trade, i-exhibit, selling or letting for hire. Ikaw ang mag-sell or either way nga imong i-distribute ang article para ibaligya. So, pwede kang makasuhan. So, ang copyright registration, of course, how can you register? First, of course, you need an application form. And then you provide a supporting document evidencing your ownership of the copyright and receipt of payment by the registration fee if the application is filed personally or by postal money order if the application is filed by registered mail. So, need pod nimo og documentary stamps. Ayan. In the correct amount. So, naman ay, usually, documentary stamps are secured from the municipality office, munisipyo. Then, 2 copies or 2 complete copies of the work or replica or picture of it. And 2 copyright notice. So need nimo og copyright notice, ipakita katong notice nga this article or this work is na under copyright. Ayan. Next class, that's for our copyright. Next class is industrial design. So ang industrial design pod class is the ornamental or aesthetic aspect of the article ang imuhang ipa-register. So the design may consist of 3-dimensional features, pwede ring 2-dimensional features such as patterns, line, or colors. So walay lain pwede mo gamit anay ikaw ra. So to be protected under those or under most national laws, an industrial design must not be functional because it must be fully out of aesthetic aspect, no? Lahi siya sa patent. Si patent is dapat naay function katong novelty, inventive step, kanang naay gamit sa industry. Si industrial design ang imong register is ang design, dapat walang function, non-functional. It must be for dapat may aesthetic value. So, when an industrial design is protected, the owner or the person or the entity that has registered the design is assured they have assured an exclusive right against unauthorized copying or imitation of the design by third parties. So, this helps to ensure a fair return on investment. So, an effective system of protection also benefit consumers and public at large by promoting fair competition and honest trade practices, encouraging creativity and promoting more aesthetically attractive products. Kanagaling mga music class, kanang familiar mo sa mga applications like Power Director, KineMaster, na yung mga music diha nga dili nila ipagamit. So dili siya basta-basta pwedeng i-publish sa YouTube. Kay if napoy for free and then katong dili for free, dili siya pwedeng i-post kay nanay copy ang uban, no? Next class are utility models. So ang registered as a utility model, so tagaan kag protection option which is designed to protect innovations that are not sufficiently inventive to meet the inventive threshold required for standard patent applications. So di ba ganina naatay patent para sa mga products nga invention, no, sa mga machines. So karon if dili makapasa sa ilahang requirement sa patent, pwede ta mo og utility model. So ang utility model naman pod class, this could be machine, implement tools, products, compositions, process improvements, or part of the same. That is practical, utility, novel, and industrial applicability. If dili makapasa ana, so pwede nimo i-register as utility model, ilang i-assess. So, ang utility model, it is entitled to 7 years of protection lang from the date of filing with no possibility of renewal. Example ani, di ba makabantay mo ang mga sakyanan, no? Ang utility models, dili siya maksud sa patent kay dili man siya new, so possible ang design sa car. So naara siya 7 years of protection. So after 7 years, di na rin pud na siya nimo, no need na pud nimo i-renew kay malamang laos na yung form, laos na yung kanyang design. So, ang 7 years of protection, it's not possible for renewal. Pag-register ng utility model, so an application for registration should contain a duly accomplished request for registration as prescribed sa Bureau. Specifications, ang dapat mauna siya ang sud sa description. It contains the title, of course. Technical field, unsa nga field na siya? Mechanical ba na siya? Chemical? Background of the utility model, brief description of the several ways of the drawings, detailed description, claims or unsay mga butang diha ang i-protect nimo nga dili nimo ipasundog sa lain, drawings, abstract of the disclosure. So unsa ra ang aspect nga imong dili i-disclose or pili mahiwaon sa public, no? Sa cellphone, ang specification i-disclose man nato. So that is for the utility utility models. So do you have any questions, class? So if there are no more questions, thank you so much for listening, class. So have a nice day and bye-bye.